All right, we're back to the ABC of collection defense. And I talked in terms of 4 quadrants, meaning, hope you can see that. You get the lawsuit, what do? I talked about that, and we end up doing the answer. And video 2, and this is the second quadrant, is about the answer and also about the counterclaim. Most importantly is that counter F. Very important. And we talked about that in video 2. Quadrant 2, quadrant 1. 3 is going to be discovery. And 4 is going to be post, hopefully, SD and trial. All opportunities to settle along the way. As you go along, your case and your ability to settle gets better. But there is a 1A video, and that is the invitation to the court. That's a scary part for somebody that is not represented by an attorney. Hell, it's scary for some attorneys too, especially. Scary is not a word I use anymore, but there may be friction with the judge, or it also could go the other way. Judge loves me, that's good for my client. But in any case, the court rules. So what do we do about that? Because it's a foreign environment. It's a terrible thought to have to get in front of a court. And in your head, you're thinking you've got anxiety and nervousness, and maybe you owe the bill and the court's going to think less of you. First of all, you're not there to approval seek, okay? You're there to beat back the lawsuit and keep the tone. We've set the tone. Keep the tone of, I have a defense. I have a counterclaim. I have a counter affidavit that counters their thoughts about me. In court, here is who I am. Hear me proud. So you're nervous about going to court. I have 2 videos for you. One is how to make a court appearance. One is why do judges or courts do what they do. The second one is more of an examination to put your mind at ease that you've done nothing wrong and anything that happens isn't a referendum on you, because I believe it is, especially during trials. But I want you to relax. And my first video, I think it's like top 10 tips to get through court, is fabulous. The show notes, just grab the show notes. And what I tried to tell you about, it's all about your preparation. So let's say you know you're going the 30th of June. And most courts have specific days where they say, okay, the 15th of June or the 30th of June is pretrial days, or Wednesdays. A lot of courts have Wednesdays a motion day. Mount Clemens is Mondays. Wayne County is Fridays is motion day. So what I want you to do, the number one thing I want you to do, and you'll see in those tips, the videos, and everything I give you in 1A. This is the 4 quadrants of defending with the ABC of collection defense. 1A is how to deal with the court at the pre-trial. So that's your first invitation to court. When you kick that answer, the clerk kicks you back a day to automatically, and you've avoided the default, that's how you know, of a pretrial notice. So now you got this nervousness, and you're going to Zoom it, baby, which is good. And that's also an opportunity to settle the case. The court wants you to settle it. The pretrial is the setting the litigation dates. We're going to have discovery to this point. We're going to have witness lists due. We're going to have exhibit lists. And the all-important summary disposition date. And that's 3 and 4. We'll talk about that in the next video. Don't be nervous. Follow my instructions. I think the number one thing is go to court appearances prior to your date. I saw this wonderful movie. It's Gene Hackman. It's called Hoosiers. And this little school that he is representing as the coach wins the state championship. Now they're going to the Nationals in Indianapolis with hundreds of thousands of people in this huge auditorium, whereas they've been playing in a school practice center with maybe 100, 200 people watching. They're intimidated. So what he does to chill them out, his players, is he makes them measure the court of the Indianapolis National Auditorium that houses 50 to 100,000 people. And he makes them see that the measurements of the court is the same as in the Podunk country school practice place they came from. He puts it in their mind. It's the same place. No matter where you go, there you are. So go to court before you're supposed to go. So the first time you show up, you're not nervous. And the video and show notes, use the show notes, detail what you should do, get to know the court, see how the ebb and flow of the court. Watch people, if you're unrepresented, watch how non-represented people work a court and take a notebook and log their successes. How does the judge react to people without an attorney? Is he rude? Is she going overboard to help? And a lot of judges will do that just for the purposes of moving their cases along. And that's another thought. They do not want to be, you are an anchor to the success of getting through the day. So be short and sweet and concise. And I talk about in my video and my show notes, know what you want, tell what you want, and then tell them again. Boom, boom, boom. He's wrong, I'm right, they didn't meet the burden of proof. That's the number one thing of these cases. You've got to show that their burden of proof hasn't been met. That's, again, the importance of the counter affidavit. But go practice like you play. Go to court sessions on those same Wednesdays or some same Mondays prior to your appearance. Introduce yourself to the bailiff. Or just watch, does the bailiff control things? How does the court treat the judge? I've been in, no lie, I've been in courts where you can see that the clerk and the judge are not getting along. I watched the clerk just scream at the judge and got away with it. Others, he or she is on the bench is not making a move without their partner clerk who's directing everything. So in your practice sessions where you go before your day, watch that. And if you see somebody has a power, because it's either the bailiff or the clerk has the power of that court, not the judge. He or she is very dependent on his staff. I've been in front of judges that are so micromanaging where I've tried a case. I remember in federal court, I tried a case. That judge tried it for me and I lost. And I snarkily said to him, hey, you tried a pretty good case. Because I didn't, and we got into it. So that's rare these days, especially at the level that we're at, the state court. But that doesn't mean the judge is the most powerful, believe it or not. The clerk or the bailiff. So if you see that, focus on them. Don't ever be late. Get there early. Even on the day that you're supposed to go, you can control your environment and your anxiety if you've been through it all before. And then you get there an hour early just to watch to confirm that you're right. And if you see some arguments that day that seem to win with the judge, incorporate them into your arguments. And I'm not saying you're going through an argument in a mere pre-trial, but sometimes, most of the time, Mr. Parker, what's your case about? And you kind of get into a little motion there. So be ready. And remember, you're always acting 3 steps ahead, meaning the argument or the advocacy of that day, you're getting ready for the most important, either motion to compel, motion to create discovery, or the most important is the This is the bad boy we always have to look out for. The white whale, if you will, is the summary disposition. I shouldn't say white whale because Ahab ended up getting eaten by the white whale, if I recall. But it's a bad boy is my point. Everything is focused on this as far as the debt collector is concerned. They are upset that you filed a counterclaim. They're going to settle it, but that's their last resort. They'll talk about it at the pre-trial and be ready for that. That's their focus. They'll go, when's the summary disposition date? And you may even be bold and go, Judge, I don't think we're going to get there. My case is so good. You can see just from my counter affidavit. You're showing the judge and talking about your case from day one. Don't be a number. Be in his head. I've been in cases where I kept repeating the same thing so many times. They write notes to themselves because they forget 2 months later when you're there on another case. They may write, oh, this is the case where the other side didn't meet their burden of proof. I've had judges say, is this the one where they didn't meet the burden of proof, Mr. Parker? I just won that case. So always be closing. ABC, baby. Always be closing. In other words, always be selling your case in a good, concise way. Don't let them think you're like nuts or something. Always be closing. Yeah, Your Honor, this is that burden of proof case where they didn't bring the right paperwork and their own paperwork shows that the assignment is all wrong. So that's one of the videos I'm attaching to this ABCs of collection defense on my membership website. The other video is why do courts or judges do what they do? Again, that's a philosophical thing that you can take it or leave it, and it'll give you some ease that it's not you, it's them, which is a great breakup, how you break up with someone. It's not me, it's you. But it is usually the court. The court is adversarial to you. Act accordingly. Not rude, but don't go looking for help from the court. If you get help, wunderbar, wonderful, mazel tov. But don't expect it. You got to help yourself because nobody else. Sometimes it feels to me like the debt collector and the court are in cahoots. And I say that liberally against my client. And I might be right in that the court wants to get this stuff off its docket. So I just need you to know that. You can do great if you follow my tips and make it easy for yourself. Practice like you play. Go practice. Be a judge yourself. Watch these two go at it when they're in front of the judge that eventually you're going to be in, and try to say, hey, I think the judge is going to go this way. She will basically say why she's going one way or the other. Or if it's just a pretrial you're watching, you can see she may have a bias or a prejudice one way or the other. There's a lot of courts that are in favor of you, of the defendant. I talk about learning the judge. I'll tell you what I said in my video. I was at the Court of Appeals. That's right before the Supreme Court. And this judge was fascinated with the gray wolf. And I found an old poem that he just loved. And I managed to squeeze that in my argument on something that no wolves are in that argument. And I got his eyes for a second, and then I got his ears. It may not work, but you have to get everything you can to win or be heard. So know your judge, know your bailiff, know your clerk, know how the court operates. Watch the ebb and flow. Are unrepresented people treated badly, or are they given help? If you are concise and just to the point, know your case, you will win such respect more than most attorneys, because the other side is scatterbrained. He's got 160 cases and he's all over the place. So if you make a case easy for a judge, you make a case easy for yourself. All right? That's a key right there. Make it easy for them, they'll make it easy for you. And that's a leg up to eliminating the bias and prejudice that may or may not be there against you and your claim. It's a debt. That's it. This is another hint for the ABCs of, this is the 1A of the ABCs of debt collection defense. Thank you.